as the Executive Board Member of YCIADR. I am also the Pro Bono Mediation Associate Counsel of CIDR. I'm currently working full-time as the Legal Research Associate of Redleaf Publishing associated with Legal Nexus, one of the prominent corporate chambers of Bangladesh. I have completed my LLB from the University of Dhaka and currently pursuing my LLM from the same institution. In this webinar, our speaker, Mr. Sandeep Valotia, will talk you through the concept of tech law and intellectual property law and how the disputes related to this are being settled through the ADR process. In today's fast-paced global business environment, it is inevitable that disputes will arise. ADR offers practical solutions without the cost, time delay, formality, and uncertainty involved with going to court. It allows technology disputes to be resolved with efficiency and expertise that cannot be found in a courtroom setting. International arbitration is a specialized form of arbitration designed for cross-border business disputes. It offers technology companies and parties doing business with them a sophisticated, neutral forum to resolve disputes on a global basis. Alternative dispute resolution in the technology space is highly specialized. Arbitrators, mediators, and neutrals must not only be skilled at handling complex commercial disputes, but also be adept at understanding and translating technical details of emerging and intertwining technology and complex multi-layered implementations and systems. Our speaker, Mr. Sandeep Valotia, is the head of legal Mali US of UAE and a member MCI at Chartered Institute of Arbitrators, CIRB of UK, and dispute resolution panelist at FICM MCN of India and UAE. He was recently selected for Arbitration Tribunal Secretary Training Program offered by HKIAC. He is also an SCMA accredited mediation advocate. I welcome you, Mr. Valotia, and thank you very much for sharing your valuable time with us. The floor is yours.
Thank you. Thanks to everyone who's behind organizing this specific webinar, and thanks a lot to the audience for joining us today. As you know, that today's topic is knowing about technology law and then venturing into IP and the resolution of IP disputes by ADR. Now, how I'm going to carry forward this session is basically I will be speaking briefly about the technology law without limiting myself to any specific jurisdiction. And then we will transition to IPR and then see what kind of disputes and how the disputes are resolved, specifically in IP sector, using the alternative dispute resolution mechanism. Now, I would appreciate if you have any questions, and if you want to ask any questions, then please feel free to ask those questions or provide your comments and feedback in the private chat session so that I can take those questions and try to address it. I'll try to be as brief as possible and try to limit myself to directly to the topics that we are going to discuss today. Now, coming back to the topics, from the face of it, from the outside, it looks like what is the relation between technology, IP, and ADR. All the three are quite specialized subjects in itself, and they require some specialized training even for the lawyers to start working in these specific domains. Especially for the law student, it's sometimes difficult to get a connection between these three separate domains that we are going to speak about. To start with, I will briefly speak about the technology law. We have all seen the development of technology around us, starting from the advent of internet, and then recently, because of the COVID, we have seen a lot of people using internet-related services and various other modules and modes to reach out to the public, whether it's video conferencing or use of the legal technology to decrease their dependence on physical meetings and also the use of materials that they were readily available earlier when you were working in the law firms. You've also seen the advent of technology in various kind of services that we are able to access in different jurisdictions. We have also seen in the recent past that there are a lot of technological advancement that have taken place in transport sector like Uber, where there is no specific law to regulate these kind of ride sharing platforms in a lot of jurisdictions, and therefore a wide variety of law, and I would say a web of law applies on these kind of emerging market to regulate these kind of platforms. So over and all, we have seen some basic advancements in the technology. Even a law student or a young lawyer or even an experienced lawyer might have seen that there are different phases through which they have gone and experienced the advancement in the technology. Now, in the recent past, a lot of people have also heard about blockchain, cryptocurrency, and ledger technology and associated technology with it. When these kind of advancements takes place, obviously there are opportunities that are created by these kind of platforms, but at the same time there are certain challenges that our society, government, or the public faces because of the advancement in these technological platforms. And for that we need law to regulate, to promote, and also to safeguard the public and the bigger interest of the public. We have seen that law usually lags behind the technology, and usually the technological advancement is first, and then it takes sometimes years or sometimes even decades for the law to follow up to catch up with the technological advancement that we see around us. When we speak about the technology law, there are wide variety of domains that fall under that technology law. Technology law is not as simple as just an IT act. It's just not one specific legislation for the protection of data. When we speak about technology law, we are speaking about the gig economy, where freelancers are able to utilize online tools to work in different jurisdictions without actually visiting those jurisdictions. We are also speaking about data and data protection laws. In the recent past, you have seen the implementation of GDPR in European Union for the protection of data, and it's a very strict regulations, and we are seeing the similar kind of debates and discussions and legislations being framed in India. Something on the line of GDPR is also getting implemented in Brazil as we speak. So there are a lot of regulations that are coming in to protect the data. And when we speak about data, obviously we have to look at it from more of a technological perspective. Then we have a lot of softwares and web development platforms that are coming. All the apps that we see on our phone have some sort of data connection points. They have a lot of software licensing, end user licensing, copyright and intellectual property issues that are associated with it. And that's again a domain where the tech law or the technology law comes into the picture. Moving forward, we have also seen some useful, at the same time highly concerning advancement in technology. One of those is the use of, or I would say the introduction of deep fakes. What exactly deep fake is basically it's a video which is not real or a simulation which is not real, but it looks real because of the use of artificial intelligence. If I have the permission, I would like to share one video on the screen so that people can realize what exactly deep fake is and how the technology law and even the international law on, say, terrorism and stuff should play together in order to address these kind of concerns. The idea that here in the initial discussion is I'm trying to touch upon different sectors that are kind of linked with the technology to give an idea to the law students that when we speak about technology law, we shouldn't be thinking very narrowly in terms of, say, Information Technology Act or just the media law. It spreads its wings in almost every kind of sector, in every kind of public interest. And therefore, it's very important that you have a broad view of things that are happening under the concept of the technology as such. So I'm just going to share a screen and run a short video for you to understand what exactly the deepfake is and what I'm talking about. I have given a brief definition of it, but it will be a bit more shocking and realistic for you if you go through the video. Then you will realize the intensity of it. So just give me a second. And can you see the screen? Dear fellow scholars, this is 2 minute papers with Dr. Carlos. It is important for you to know that everybody can fix that. You can turn your head around. Mouth movements are integrated, and eye movements are also translated into the common language. And of course, as we always say, and it will be even better than yes, it's one of them. To use this technique, all you need to do is record the video of yourself and just one image of the target subject, run this in the environment, and there you go. If you stay until the end of this video, you will see even more people introducing themselves. There's nothing many important gestures are being translated, such as wow, and eye movement. But what's even better is that even full body movement works. Absolutely incredible. Now, there are plenty of techniques out there that can create new things, many of which we have talked about in this series. So, what sets this one? All right. So, if you have the opportunity to go through the video, and you can search for more deepfake videos online, and you will realize that there are a lot of pressing concerns when it comes to deepfake videos. It revolves around the technology law. Obviously, it revolves around a lot of public policy associated with corruption, associated with terrorism laws, associated with national defense, and various other sectors that needs to be touched upon. And that also falls under the wider gambit of the technology law. Then we have seen the increase in the fintech sector as such, where there are a lot of startups that are coming up to provide certain solutions related to financial and technological issues. You have a lot of payment process, new type of payment processors that are coming up to accept your credit card and debit card, and there is a necessity of regulating those kind of payment gateways. We have seen a lot of crypto exchange that are coming up, which basically provide solutions for you to exchange your cryptocurrency into fiat currency or do the transactions and stuff. We also have certain traditional platforms that are coming up, which kind of falls into the gray area of laws in a lot of jurisdictions, like a platform known as Claros. What basically Claros does is it provides a decentralized dispute resolution mechanism, but it does collect data, it does rely on tokens, and therefore the country's digital laws and the country's laws associated with the crypto assets do kick in and needs to be applied on these kind of platforms. So from this broad discussion that we had, students will basically have an idea that when we speak about technology law nowadays, it's just not limited to you going on e-commerce platform and just buying certain services and thinking that only that's the sphere where the technology law is applicable. It's applicable on new form of the technological services that we use, whether it's associated with gig economy. A lot of countries are getting now serious about data protection. That's where, again, there is a lot of implications of the technology law. We have seen the growth of blockchain and crypto assets and the platforms associated with it, whether it's a decentralized app or other sort of exchanges. And that's where the technology law is applicable. We have seen in the traditional platforms where software licensing and all those kind of end user licensing agreements that we draft, where the technology law again plays a very important factor Then you have seen this video of deepfake. Now in this video is what exactly is happening is someone using technology, especially artificial intelligence, where they are depicting themselves, whatever they are saying, as someone else. So even you can see what I'm speaking, I can use a deepfake video and make myself look like uh, President Trump. And a lot of people might believe it because it looks so realistic, and it's getting so easy and so less costly to create these kind of platforms that it gets difficult for people to track. Now, coming back to say IP, intellectual property, and how that relates with the technology is whenever you discuss about any kind of a technological platform, you always have some sort of coding or a software, or you might be sharing some sort of intellectual property when you are drafting a software licensing agreement, software development agreement, and there are a lot of intellectual property aspects that are involved into it. Once an intellectual property is involved into it, you do look towards how to resolve a dispute if tomorrow a dispute arises in those kind of contracts. Let's take a very simple example of say software licensing agreement. Party A and B are entering into a software licensing agreement where one party is licensing software to the other side. Obviously, there will be a very specialized focus on certain clauses that deals with intellectual property. That means that you also need to look into aspects where if the contract is breached, then how you are going to resolve the dispute, what are the methods that you are going to use to resolve the disputes. Going back to the traditional method of resolving the disputes, we have seen, especially in the developing jurisdictions, that traditional court system is not something that can be highly relied upon. It takes years for the resolution of disputes in intellectual property sphere. It takes years to even get a relief related to an injunction to be enforced, or the relief to be claimed by the courts when it comes to the traditional court mechanism. And that has been there, at least in Indian jurisdiction. There are certain landmark judgments where even the Supreme Court of India has given an opinion that these kind of disputes where you have certain high interest and actions needs to be taken more quickly should be resolved through alternative dispute resolution mechanism, and there should be a possibility of the parties to gain a speedy relief compared to what they have to go through 5 years or 3 years or 2 years through the court to even get the basic relief related to intellectual property when it comes to these kind of contracts. But and especially in jurisdictions like India and a lot of other developing countries, we see that the courts are highly overburdened with a lot of uh, disputes, and are slow to function because of various reasons, and therefore they are not efficient enough to resolve these disputes quickly. In a survey that was done by World Intellectual Property Organization, it was found out that most of the people who engage into the software development agreements, or the tech side of the contractual drafting, prefer a dispute resolution mechanism that is not only less costly but also able to provide solutions or able to provide relief way more quickly compared to what traditional courts are able to provide. In the same survey, the respondents also expressed the desire that they are looking for someone who has expertise in specific kind of dispute to be able to sit as a mediator and arbitrator. They're also looking to ensure that there is confidentiality when these kind of disputes are resolved, and unnecessary information doesn't go out in the public because that might impact their business. Considering all those scenarios, we sometimes can conclude that the traditional court system in developing countries is not up to the mark to provide an specialized or an expert judge who can just handle IP disputes, more complicated IP disputes in technological sphere. Obviously, there is a lack of flexibility when it comes to resolving these disputes. A lot of technological side of the contracts are sometimes multi-jurisdiction. That means more than one jurisdiction is applicable, and some of the contracts are highly specialized. Say, suppose there is a contract between the parties for aspects related to blockchain and the development of blockchain, or migrating one specific platform from a centralized platform to a decentralized platform on a blockchain system. Now, how many judges you expect would be knowing about these kind of technology? If they don't know, they have to take more time to understand it. But as long as these disputes can be referred to someone who's specialized, but not necessarily a judge in a traditional sense, as an arbitrator or mediator, there are more chances of parties also getting satisfied, and at the same time, the dispute can be resolved in a more quick and efficient manner. So those are the places where we see a lot of use case scenarios and a lot of requirement for having an alternative dispute resolution mechanism for IP and tech disputes. But when we speak about arbitration, we cannot ignore certain aspects of arbitrability, whether intellectual property disputes, whether all kind of intellectual property disputes are arbitrable or not. At least in Indian scenario, there is some clarity on those aspects. We have a Supreme Court judgment, a Boozalan judgment, where basically it was clarified what kind of disputes are arbitrable and what kind of disputes are not arbitrable. As per that judgment, rights in rem are non-arbitrable. Rights in rem are basically those issues where the rights of general public are getting impacted, like the criminal cases and the tax related issues or anti-competition related issues, which are technically not arbitrable. Then we have rights in personam, where a contractual dispute will only impact the right of a specific individual who are party to those contracts, or impacts the private individual, and those kind of disputes can go for arbitration. Those kind of disputes are mostly commercial and business in the nature. So when it comes to, say, intellectual property, every jurisdiction might have their own test to figure out what exactly is the scenario, whether that specific dispute can go for arbitration or not. There are certain well-known dispute resolution platforms around the world which specialize specifically in dispute resolution of text, where one of those is World Intellectual Property Organization, which is one of the specialized bodies of United Nations, and they basically focus on IP and tech disputes. They have around, if I'm not wrong, a couple of hundred specialized arbitrators and mediators who have specific focus on resolving disputes under IP and technology. And those are the platforms that are basically used by the parties which are concerned about resolving their disputes in a more sophisticated manner. CIADR is also making its way towards more international recognition in terms of resolving disputes. It has promoted ODR to a significant level, and we see these kind of platforms and these kind of arbitration and mediation institutes coming up and trying to assist to resolve the disputes through these tech-based contracts that are necessary for resolution of the dispute. So this is the basic overview of the technology, IP, and the use of ADR mechanism. I remember we had another webinar with the CIADR where we discussed about the major difference between negotiation, mediation, arbitration, and we compared it with litigation quite in depth. And from that webinar, if you can recall, and if we have attendees who have attended that webinar and are also attending this one, you will see that there is a major difference when it comes to litigation and alternative dispute resolution mechanism. One of the key factor when it comes to resolution of IP disputes through ADR is time, its efficiency, it's the speed that a lot of parties prefer. Because if you have entered into some sort of licensing agreement and you see that the licensing agreement is being violated, you can't wait for 2 or 3 years for it to be enforced. You want the actions to be taken as quickly as possible, and by someone who is an expert in that specific domain, who can assist you to claim the damages and compensation that you might be suffering within the parameters of the law. Another important thing is also preserving the confidentiality. Litigation to a great extent doesn't provide you with that kind of confidentiality, and when you are working on certain kind of tech projects, you don't want your dirty laundry to be out there, and you want to have that benefit of confidentiality, which is quite extensively provided in negotiation, mediation, and arbitration, and these kind of dispute resolution mechanisms compared to say litigation. So that's the broad overview of resolving disputes through ADR, specifically in IP sector. And I think now I can take a couple of questions and we can probably carry forward from there. Is can you hear me?
Yes, Mr. Sandeep.
Yes, if participants have any questions or comment or would like to have some sort of discussion on any specific point, then we can
Yeah, sure.
take those questions.
We still don't have any questions from our viewers, but I have a question for you, Mr. Valotia.
Sure.
I want to ask you that I have seen some recent cases where the banks can be involved in a variety of IP related disputes. For example, in connection with the use of a bank's trademark or the development of software systems. What is your take on this particular issue? Like, can such disputes be solved through ADR successfully? What do you think?
Well, it again depends upon the national laws of the specific country when it comes to the resolution of IP disputes. Rather than making a specific example, I would say it broadly depends upon what kind of the dispute it is and whether the national laws of that specific jurisdiction allows for these kind of disputes to be resolved through ADR or not. I will give you an example of India. In India, IP disputes, as long as it's about monetary aspects of intellectual property, any dispute that involves the monetary aspect of the intellectual property, yes, it can be broadly resolved through ADR. But when it comes about the infringement issues, it cannot be resolved through ADR because the infringement is something that a government body is going to decide whether you have that kind of patent right, whether the bank has that patent right or not, and if it does, to what extent it has been violated. It's not up to an arbitrator to decide whether party A has the patent on this or whether it was rightly obtained or not. It's up to the government bodies, and that's the reason we have these patent offices and trademark offices in almost every jurisdiction. IP is again a territorial right, which is given by the government for a limited duration to us. It's not like a just normal commercial right, and therefore that's where the gray area is, and that's where the confusion usually lies in specific jurisdiction when it comes to resolution of uh, disputes. But coming back to your question, if it's purely a commercial transaction, if it's purely about in a specific IP related dispute, you were supposed to get X amount of money, but you didn't receive, you received something less. I don't see any reason under the sun why it cannot go for mediation, it cannot go for arbitration. I honestly believe that, and I've been part of certain tech disputes which have been resolved through ADR and which have been even resolved through mediation and arbitration, to be very precise. There are certain disputes that I have been part under World Intellectual Property Organization. I have seen the efficiency that is there in resolution of these kind of disputes far better than when it comes to the traditional court system, because a very stringent process that you need to follow for resolving disputes through the traditional system. But over here, you have very specialized focus only on resolving IP disputes. The rules are drafted in such a way that it promotes. You have a look at World Intellectual Property Organization's rules, and you will realize that it are very oriented towards providing a speedy resolution of disputes when it comes to intellectual property. They have a panel of experts who know about these kind of specific domains. They have experience and they have expertise in these kind of domains. So whenever some disputes come in front of them, they are able to immediately judge whether what is right and what is wrong, are able to appreciate their evidences more comprehensively compared to someone who might have an experience of say 10 or 15 years within the judiciary as a judge, but is going to deal with certain kind of technology or IP dispute for the first time, and it's a new technology or something, it will probably take more time. So that's the reason I very strongly feel that these kind of disputes can definitely be resolved and have been part of it in a lot of our IP related contracts. As an in-house lawyer, I also prefer to have some sort of alternative dispute resolution mechanism rather than purely relying on the local courts, because those things do take time and there is a lot of negotiation that goes when it comes to an in-house lawyer's perspective, which court should have the jurisdiction, and therefore you try to opt for something neutral and that you can only do if it's an ADR mechanism. And then you also have the flexibility of deciding the timeline. At the very beginning, you have the flexibility of deciding which kind of arbitrator you want and how experienced that arbitrator should be in those kind of contractual dispute. And these kind of flexibilities are not available for you in the traditional court system. So just summarizing my answer to your question, I do strongly believe that in these times, I don't see any scenario why you shouldn't be using mediation and arbitration. Being an in-house lawyer, I I am not comfortable going with the traditional court system when it comes to intellectual property, as far as the law permits, as far as the governing law, the substantial law permits us to take it towards mediation and arbitration. It's just that you have to think it very strategically, and you have to have right center in your contract, which is capable of providing you with the right arbitrators and mediators, and is capable of handling those disputes very efficiently.
Thank you very much, Mr. Balotia. I want to ask you another question, referring to one sentence that you said that we can choose any of the processes like mediation or arbitration. So I want to ask you, which process is more suitable for IP and tech law related dispute? Like which one can provide more advantages than other between mediation and arbitration? What's your take on this?
Well, that's something that any in-house law or any lawyer usually struggles to find out whether first the decision needs to be made whether the litigation or ADR. Once you have made a decision that you want to go with ADR, you start thinking, okay, it has to be multi-tiered dispute resolution clause with negotiation, mediation, and arbitration, everything involved into it, or just purely arbitration or purely mediation. How do you want to go ahead with it? Uh, it also depends upon the lawyer what kind of choices they have and what they personally prefer. It does bring their own personality and their own past experience and training when they draft the contracts. And it also depends upon the nature of dispute that you have at hand, and how you wish to be resolved, and how many are experienced mediators you can find in that jurisdiction who are capable of providing their services to you. I personally would prefer uh, some sort of a mix of mediation and arbitration. First, the dispute to go for mediation and then for arbitration, because the entire idea of for me to move towards alternative dispute resolution is to not fight, is to at least give another opportunity for the parties to have that fair discussion and then take something to arbitration. Because arbitration, although it is an alternative, but still only one party wins and that another party loses. So sometimes, especially when it comes to the contractual disputes where you are having some sort of software development or something you are developing from scratch, there is a lot of communication requirement between both the sides, whether it's a software developer, service provider, and the client. And I've seen that in my experience, most of the disputes comes because of the lack of communication or confusion that is created during the contractual negotiation. And instead of going directly for arbitration, it's important that you have a mediation or negotiation clause where you are able to get an expert mediator who is able to bring the parties on the table and have that honest discussion between the parties. And then they also hopefully come with a lawyer who understands the importance of mediation as well. But if that fails, then obviously you have to go for arbitration or litigation, depending upon what you have put it in your clause. I prefer to go for arbitration if the net worth of the contract is decent, it's huge. But if it's a small contract with the net value of the entire contract not being such a big amount, you still end up going for arbitration. You don't want to overcomplicate it and pay a lot of money to the mediator, then to the arbitrator, and then again you have to go for the litigation. There's no point of wasting your money when your disputes are so small, but you don't have a cheaper way of resolving. Because it's just not about the resolution of the dispute, it's also about cost factor that is involved. So if your contract is worth 10,000 USD, there is no point of having big arbitration institutes involved into it, because you will end up losing more money than what you are going to gain at the end. But another important thing that parties, when they are drafting these kind of arbitration or I would say mediation and arbitration clause, where you have first mediation and then arbitration, or first mediation then litigation, one thing that they have to, and I see a lot of mistakes being made on these kind of aspects in the contract, is you have to be very precise when it comes to drafting mediation clauses, because a lot of time parties just put that there will be a mediation between the parties, and if the mediation is not successful, they can go for arbitration. But mediation between who? Who should be attending the mediation? Is the mediation between the lawyers or the top executives? How long that mediation is going to last? Is it going to last for 30 days, 60 days? What does it mean to fail mediation, how exactly your mediation is going to fail. You need to provide certain timeline, you need to provide certain certainty, you need to provide certain details about how to start a mediation and when a mediation will be considered as failed or finished, and when you can go ahead with arbitration. In arbitration clauses, we do see that the parties are very precise and they do provide the details, but sometimes we see that arbitration, multi-tiered dispute resolution clauses where mediation aspect is kind of ignored. It just says the mediation, and when tomorrow dispute arises, one party will say, "Hey, it says mediation. We haven't gone through the mediation yet," but it just says that you have to go through the mediation. So when it ends after a year, after 6 months, how you are going to do it. And the problem is that once you leave those kind of clauses so blank or vague, that's a contention point when it comes to the court. Then every drafting of that clause can be contended in front of the court. And the ultimate purpose of the parties while drafting the contract was to reduce the cost, to reduce the time. But the poor drafting leads you to spend more time and more money. So these clauses should not be copy pasted. You should look at the transaction. You should look at the intellectual property that you are trying to protect. You should be very careful. Okay, this kind of things, these kind of disputes can be arbitrated or not, and carve out those kind of disputes which cannot go for the arbitration, and mention only those kind of disputes which can go for arbitration, so that there is no unnecessary issues that you face where one party is dragging the other party in front of the court because of the dispute resolution clause.
Thank you very much, Mr. Valotia. I want to ask you that what things can possibly go wrong in an intellectual property law related ADR proceeding? Can you tell us some incidents from your own experience while dealing with some of your own cases? We do know that ADR proceedings are completely confidential. You can't actually share with us the name or reference or anything. Just if you want to tell us like a story, so we can have a practical aspect and over outlook of the things, that how things can go wrong actually.
Uh, Coming from the in-house background, the first thing that I look at is obviously the contract, because even in the disputes, if you are a litigation lawyer or if you are an arbitrator, you start your process with looking at the contract. And working as in-house lawyer, I think most of the disputes seeds are sown when a contract is basically getting drafted, because that's where the issues arise. So when disputes do arise, it's usually, and in most of the cases when it comes to the software and intellectual property, is because of the lack of proper drafting of the contracts. Most of the contracts you see, if it's not a high end contract with a lot of money involved into it, you see a lot of copy pasted clauses where parties, just for the sake of it, have hurriedly drafted the contract because they want to enter into the detail. And when these kind of things goes, everything is very, I would say, good and romantic feeling between the parties, and they think nothing will go wrong, and they end up drafting the contract in unnecessary hurry, and they miss out on certain clauses, they miss out on certain languages. And once the dispute actually arises, you realize that, okay, shit, this clause is not the same, this is not what we meant, but now here we are and we have to fight it out, and every party wants to take the advantage of that poorly drafted clause in their favor. So the first thing, that whenever anyone who's entering into any kind of IP disputes, it's not a clause that you can just copy paste. You have to realize what kind of IP you want to protect, what kind of risk that you want to protect, and you have to anticipate those risks well in advance to draft a proper clause. It's, if you rely on copy pasting the clauses for these kind of disputes, it's not going to work out when actually there is a dispute. So that's the first issue that parties face. The second issue that parties face is not getting the right lawyer. Usually parties go ahead with some senior counsel or someone who has more of experience in litigation side, but not on handling the intricacies of intellectual property and technology law. I have seen certain junior lawyers having very good understanding of technology law and associated intellectual property issues than a lawyer who's having like 10 years or 15 years of experience. So I do understand the experience matter a lot, and it brings a lot of I would say details associated with it and a lot of exposure associated with it. But you should always also try to look out for a lawyer who has experience in dealing with the technology day in, day out, rather than relying on someone who just experienced and probably doesn't know how to use uh, the basic gadgets and stuff, because it does play out an important factor when they have to understand the technology. Because I've seen among the lawyers also, they think that they don't need to understand the technology for them to be a technology lawyer, but that's not the case. It's always good that you know about the basics of the technology, you know about the emerging technologies that are taking place, and you do some sort of training or the courses, because once a dispute arises, you will be able to better understand it, because you know what is happening in front of you. You know why the parties have drafted that clause. You know what this term specifically mean in the industry, and you are able to find a way around and do the stuff. So the second problem is not getting the right lawyer when it comes to the dispute resolution or these kind of contracts. And the third is not having the clauses drafted in a well researched manner. You see the parties sometimes go beyond the scope of what was actually there in the contract. So, say, suppose they are coming up with the new app, and the new app has three core features, and the parties ended up drafting those three core feature related contract. But later on, after 6 months into the project, they realize that, okay, let's also add this one additional small feature, and they don't make it part of their contract. And tomorrow the project gets delayed. From the developer side, their arguments usually will be, hey, you made a change in the scope of work and therefore the project is delayed. But from the other side, the understanding is usually that it's not a major project change, and even if this feature was not added, we are still fine. We just recommended you to add this one specific feature. So I have seen that a lot of disputes do arise once you have really good negotiated contracts, you have everything in place, but during the project time, you keep on making the changes, and that might delay the project, and therefore you have certain additional issues when it comes to intellectual property. And last but not the least, parties needs to also understand that just like any other law, intellectual property is also a territorial right, which basically means that you need to look at their respective jurisdictions' laws to understand intellectual property in a better way. There are few jurisdictions where if you are an employer and you are getting an employee, all the intellectual property that they are developing by default is the intellectual property of the company under which they are employed. Pretty reasonable, pretty logical stuff, right? But there
Right.
are jurisdictions where a company can only have access or only have the right over three consecutive intellectual property that is developed, or five consecutive intellectual property that is developed. Beyond that, they don't have any right on that intellectual property. They have to sign a fresh side agreement for an employee to give that right to them. And like this, I can give multiple examples only related to intellectual property. But what happens is we have a broad understanding of intellectual property and we try to rely on those kind of clauses. But taking this example where after every fourth or fifth intellectual property that is developed by the employee, you don't have right over the subsequent intellectual property. If you don't know about these small details, what will end up happening is after say 6 months, you will claim a right on something that your employee developed and then realize, okay, you don't have right over it, although you presume that it's very logical for you to have a right over it. So these kind of presumptions also create a lot of issues. Obviously, the lawyer who's drafting those kind of agreements might not be with the company. He might have resigned, he might have moved for a better opportunity, or she might have left because of whatever reasons. So there's no one to explain you why you didn't put these clauses. But it's very important for the parties to understand that these are the kind of small details that matter a lot when it comes to the contractual issues and will give you an upper hand when it comes to a dispute resolution process.
Thank you, Mr. Velotia. I have another question popped up in my mind. That is, you have been talking about the specific jurisdictional powers or jurisdictional thing in each and every state. That's very important. I can understand. My question is here that what about suppose there's a dispute happening between two companies belonging from two different states. So in such a case, it will become an probably it may become a case of international arbitration. So in such a case, do you think what do you think, is there any such international statute that may prevail over the national laws of such particular countries, or if there isn't any, do you think there should one statute that needs to be developed in recent years? Because due to the COVID-19 situation, we can see that everything is going digitalized, so we need to emphasize more on this aspect. So, what's your take on this?
Well, when it comes to international contracts, it's just not IP in every aspect, whether it has some sort of international taxation angle, whether it has international contract angle. there is no such thing as international contract law, but you do have certain guiding principles and you do have certain rules that guide you when it comes to the international contracts. When speaking about IP, obviously IP is a territorial right, and that means that a specific government provides you patents, provides you trademark right, provides you copyright under their own legislation and stuff. But parties do end up entering into international contracts with one company is from some other jurisdiction, there is another company from another jurisdiction. At that moment, the boilerplate provisions like jurisdiction clause that you have or the governing law clause that you have plays a very important factor in implementing a strategy. We have seen that parties, if they don't have the right legal advice, end up just copy pasting some sort of jurisdiction clause or governing law clause without analyzing that how they want to have the impact on their agreements. So say suppose party A is based out of US and it has certain intellectual property and it is providing that intellectual property to party B, which is based out of India. You need to have a look at the legislation of both the countries, because tomorrow when you are going to enforce certain court judgments, you need to have an understanding of the India as well, because the party B's assets are probably located over there. You need to have a broad understanding of party B's jurisdiction, and you also need to have detailed understanding of your own country's law, and then you make a comparison which law needs to apply in your contract. And it's not that you can always select when it comes to the intellectual property rights that okay, my patent will be governed by India or Australia. No, it will definitely be governed under the provisions of the country which has provided you intellectual property, but only the commercial aspects of it will be governed by the governing law that you are applying in your contract. A lot of countries also have specific restrictions about licensing, and they have certain regulations to what extent you can provide the licensing and how to provide the license. So even though the laws are applicable of your jurisdiction, but if you're licensing to some other jurisdiction related companies, you have to look at the specific licensing regime. So you can go ahead with arbitration, but obviously arbitration cannot be done on non-arbitrable disputes. So if you are looking at Indian scenario, you have to very deeply analyze that the intellectual property aspects that are involved in your contract. How do you categorize between arbitrable disputes for IP and non-arbitrable disputes between IP? And that distinction plays an important role in almost all kind of international contracts where there is a software development. And especially because not only because of COVID, even before the COVID also, we have seen when it comes to development of technology, there are people who are hired and there are companies which are hired from all around the world, because that's the beauty of this specific industry. Means when I have to develop some software, I don't need to completely rely on someone who's based out of here in United Arab Emirates. I can take people from around the world and take their assistance. It's not like developing a building that I need the construction workers and engineers to be on site. It's all on the web, and this way you can pool out good resources and more talented people and reduce the cost when you are doing this. So in all these kind of contracts, there is always an international angle to it, but it has to be very clearly drafted in terms of to what extent those kind of intellectual property rights can be given to you under that private limited contract that you have. Say suppose you hire someone from India while sitting here from United Arab Emirates and they develop certain kind of intellectual property. You need to look at whether it's their intellectual property or not, whether it's registered as per the Indian laws or not, whether it can be transferred as per the Indian laws or not. And if it can be transferred to you, what is the process to transfer? Because there's always a process to transfer these kind of intellectual property. You need to have certain things in writing, because if you don't follow the proper process, it will not be considered as a proper transfer of those intangible assets to you. So you need to take care of those kind of complexities as well when you are entering into these kind of contracts.
Thank you very much, Mr. Velotia. So I guess I'm out of questions right now.
No,
And
no problem. I will carry forward from here for a while, and I think are we running out of time?
yeah, thank you very much. And I've already asked the question from our guests, and there is no more new questions. So
No problem. So do we have more time, or are we short on time?
It's totally up to you. If you want to end your speech by sharing some more details, you're totally
Yes.
welcome.
Uh, I know there are a lot of law students who are attending this webinar. I know there are certain young lawyers as well who are attending this program and this webinar. And there are certain things that I wanted to say for them because obviously technology is something that's going to stay around. Just the phase of it, just the face of it, just the look of it keeps on changing. Something new keeps on happening, and that's where the major difference lies. Now, if a law student or a young lawyer believes that this is not their sphere or it's not something that interests them, then to a certain extent they are wrong, because whatever kind of work you do, there will be some sort of technological angle to it. I have seen even in the construction industry, the disputes are getting resolved by decentralized arbitration on Claro's platform, which is using blockchain. So who thought of that a construction lawyer would be required to sometime know about, say, blockchain to a certain extent? There are real estate related issues that are getting resolved on the blockchain and other technological platforms as well. If you are a human rights lawyer and if you're a public lawyer, you will know that the video that I have shown you about deep fakes plays a very important role even at the government level. So my advice to the students would be that please go out, look for the new technological platforms that are out there and try to do online courses on them. I've been doing and I've been promoting online courses from my side since 2013 when I started doing it. And it does help you in building your CV. I know because of the COVID, a lot of law schools are under lockdown. You might not have physical opportunities for you to go to a specific law firm and try to do the internship. So this is the time where you can study about slightly more about the technology and see whatever the free courses are available out there and start exploring, because as long as you are in touch with the technology, there are certain opportunities that will keep on opening for you, and you will have certain kind of prospectus in growing your career in that one specific domain. To name a few, you can start doing probably the courses on, say, data protection, especially under the GDPR. If you're looking to move out and work on international atmosphere, you have a lot of amazing and good courses on blockchain, which explains the blockchain basics in a very precise way, in a very simplistic way, because that's again the core of various other kinds of domain. You have courses on fintech and law on Coursera. Go there and try to do those courses, read more about those kind of courses and stuff. Another thing that you can do is there are a lot of startups that are coming up in these technological sphere, and what these startups do is they publish a white paper which is basically a description of how things will go, what is the problem that they are trying to solve, how they are going to solve and stuff. Go and read those white papers, because that will give you a deep insight on the technological challenges that they are going to resolve and what kind of laws will apply. You will see very prominent startups which are doing really good but are not probably in compliance with the local laws once you go through their white paper. And that's where something you can start advising them probably as a law student, because these startups don't have that kind of money to hire big law firms or something. And that's where a law student who's probably in their last year or second last year of the law school can reach out to these platforms and say, I'm really good at drafting terms and conditions, privacy policy, and cookies policy, and then help me in giving an opportunity so that I can help you out. I can draft you basic contracts, I can draft you basic NDA. So try to go out and reach out to these small startups, because they are looking out for help. It's just the money factor and they can't afford the lawyers. And you as a law student won't lose much, and you will get initial understanding of working with these kind of startups and these kind of platforms. So that's kind of a concluding remark from my end, unless we have more questions to answer.
Thank you very much, Mr. Valotia. From our today's discussion, it is completely clear that the field of tech law is going to be prevailed and ruled by the young lawyers of today's generation, because they are very much ahead in technological terms and laws and etc. Because rather than our senior lawyers, because the generation is lagging behind in technological knowledge than ours. So I think the suggestions that you gave at last will be very much helpful for young lawyers like me and others. And yeah, I very much appreciate your suggestion about doing courses on Coursera and other online platforms. And I am even doing some courses on arbitration and others, and they are really very helpful. I bet on this. So thank you very much, Mr. Valotia. Today's
Sure.
webinar was very much helpful and informative, and I have learned so many new things. So I can thank you enough for attending our
Thank
today's
you.
show.
Thank you so much, and thanks a lot to entire team behind CIADR for inviting me, and all the audience who are out there and have been part of this specific webinar. Thanks a lot for everyone's time, and hope to see you guys again.
Sure. Thank you very much, Mr.